The law matters, and we're here to help you understand it a bit better. Hi, I'm Debra Morais, your host and moderator. For nearly a decade now, this program has been dedicated to making legal topics and information accessible to you. We offer clear insights, real-life examples, and practical advice to help you navigate the complexities of the law. A solid understanding of the law puts you in a better position to protect yourself, your family, and your business. Through our discussions, you may find that you're able to handle some issues yourself. However, if you decide to seek outside counsel, you'll be better prepared, and so will the counsel you select. As always, our goal is to help you achieve the best possible results while saving a little time and hopefully some money too. As always, we want to welcome and thank again Attorney David Bazar from the Bazar and Associates Law Firm in East Providence, who continues to weigh in on the topics that we present every session. Today, the Supreme Court. This is a term that's likely poised to be quite consequential. First, we'll talk about its role, its calendar, this thing called its shadow calendar, its cases, and about those cases. Since President Trump returned to office in January, the U.S. Supreme Court has dealt with a series of cases involving challenges about his presidency, his administration. These cases have involved such a wide variety of topics: the U.S. Federal Reserve, tariffs, birthright citizenship, transgender rights, firings of federal employees, agency officials, dismantling of the education system. We won't be able to cover all of those, but we will do a few highlights. So while we can't cover them all, we probably should start with the basics, the primer, David. So I'm going to toss the ball to you when it comes to the Supreme Court. How does a case even get to the Supreme Court?
So typically, a case is brought to the Supreme Court by what's called a writ of certiorari. And that means somebody is appealing generally from a court of appeals somewhere. And let's go back to the federal system. We start at the district court, which is the trial level. Rhode Island District Court is the district for Rhode Island has just one. Many states have several different districts within their states. And then if you don't like the result at the district court level, you can appeal to the Circuit Court of Appeals. And different districts are in different circuits. So there's the First Circuit and Second Circuit in New York and so forth. And then after you've been heard there, and there's another round of appeals that happen there, which can be both a 3-panel hearing from the circuit court, and then you can request an en banc, which is the whole circuit to hear it as sort of like a rehearing. And then after all those rights have been exhausted, you could file what's called a writ of certiorari, which is an appeal, but it's not a direct appeal, it's not a right of appeal, but a request, so to speak, for the Supreme Court to hear your case. And many, many cases, there are writs of certiorari filed for. In very few cases does the court generally vote to hear the appeal.
There's something called the rule of 4. It takes 4 of them to vote on hearing it or not. Is that still the case?
Yes. So when a case is brought to the Supreme Court by a writ of certiorari, it's reviewed by all of the justices, and at least 4 have to agree that there's merit to the case of some important law or significance or something that merits them taking the time to hear the case in the term in which it is brought.
Is that likely to be contentious depending on the makeup of the court and the makeup of the cases that are submitted on appeal?
I haven't sat on the Supreme Court, so I can't tell you what it's like, except I will say this. In the past, historically, there's been a collegiality amongst all of the justices, no matter what their leanings may or may not be. And those are not political leanings, but they're more of leanings of how they view the law. There was Justice Scalia, who was considered a very conservative-leaning judge and read the law as in a certain way that met up with that. and Justice Ruth Bader Ginsburg, who was considered more liberal and had a more liberal approach to her interpretation of the law. Yet they were very good friends, and they were collegial, and they respected each other's opinions if they didn't agree with them, but that's how the court was. I can't tell you it's not that way today. It very may well be, but from the outside lens, there's a lot of political spotlight put on the court, which shouldn't be. That's not the way the court was designed. It's not the way our government was set up to be designed.
And so I guess that brings us to the topic, too, about its calendar, what its calendar's about, and this thing that's called a shadow calendar, wondering how the political climate, such as it is, might impact that.
Yeah.
So describe it.
Again, it shouldn't have any impact. And from the outside perspective, many people feel it does. And that's because a lot of the cases that have been brought up through the quote unquote shadow calendar are cases that aren't heard in full. They're not briefed, at least at the point of the shadow calendar, and argued in front of the entire Supreme Court. Rather, they're decided what I'm going to call summarily. Maybe on some law, maybe on standing, maybe on some other reasoning, but the court has been issuing more and more opinions through that docket than they ever have in the past.
So approximately how many cases are heard in that, what is it, October to June calendar, such as it is?
Yeah, I'm not
150?
Say that again?
150?
I think that might, if it is, that's the high end. Because remember what happens in these cases, and I'm not sure that it's that many.
100 to 130?
Yeah, maybe. Because these cases are briefed in their very extensive briefs that are filed, and then they're argued, and they're time-consuming arguments. And then generally what happens is after the arguments in a particular day, the court will meet in conference to discuss and maybe take a straw vote to what the leanings may be. And if they have some consensus or whatever, then the Chief Justice will assign the case to somebody to write the decision.
And someone to write the counter decision
If
later?
there's a dissent.
If there's a dissent.
Or concurrence that they don't 100% agree on what happened, but they think the outcome should be the same as the majority perhaps, but for different reasons.
Sounds great. So two other terms that are referred to in discussions about the calendar, something that's called, and they have alternating periods of sittings when they're hearing the arguments versus recesses, which I thought was a recess. It's what's intended for private conferences and opinion writing. So how does that get paced, David? They have an hour to hear a case on both sides, or how does that play out?
The court sets what the time limits may be. Most cases probably have a certain set time limit. There may be some very important issues that require more time where the court may generally be able to give a person on each side, an attorney, more time to argue, but the court sets the time, and as you're arguing in the court, you'll have lights, and it'll be green, and then it may turn yellow, and then it's red, and when it's red, you're stopping.
So I understand there's always live audio feeds when they're, or streaming, as they call it now, so someone can hear it. I don't know if they actually showed the video. Would someone likely be able to see what's going on?
As far as I know, last I knew, the Supreme Court does not have live video.
Just the audio?
Yes. And it can be interesting because the audio, you're listening to it, and depending on if you jumped in the middle or not, you're trying to sometimes sit and, which side are you arguing again? To figure out who's arguing what. But yes, the audio has been available for some time, and many very important cases, sometimes they'll carry those on different stations, and you can listen to the arguments. And I do remember, I think there was the case where they were arguing over what the extent of the executive immunity might be. And I actually was driving, so I listened to some of that. Not too often I get a chance to listen to a Supreme Court argument. But The video, it's in the federal system, you're not going to see the OJ trial on TV in the federal system generally.
Got it. So if once the Supreme Court has decided what cases they'll hear, how do they decide which ones first? I would imagine that things that our president wants to have heard might have some sway, or is that not true? Or is that just how do they decide what's going to that?
Yeah.
And describe what that shadow docket is about?
Yeah, so again, the shadow docket, they're taking up, and again, it's been more and more cases where they think they need to weigh in very quickly. Appeals from circuit courts giving injunctions against the executive branch from doing certain things, deciding whether or not injunctions that are nationwide should be only limited to the circuit in which the appeal is coming from, or district court that heard it for just their district. And so they've been weighing in on a lot of things in that shadow docket quickly on those types of things, where generally they wouldn't weigh in at that level, or they would wait until they took it up on full appeal and heard it. So it's kind of interesting to watch the little transition on that. And I think that may be part and parcel of what is going on in the number of cases that are being filed as the executive branch tries to extend its authority beyond what it traditionally is. Because if you remember, our Constitution was set up with different checks and balances, and each branch had certain authority laid out in the Constitution. And Congress had the authority to tax and spend and create legislation. And the executive branch was in charge of carrying out the duties of the executive, which are managing how the money's being spent, and other law enforcement, DOJ, that type of thing. And the Supreme Court's supposed to review to determine whether things are constitutional or violate any other federal laws and that type of thing. And as the executive branch tries to extend its authority, they are pushing back on the authority of the judicial branch to even weigh in what they're doing with its power to issue injunctions and that type of thing.
So we do need to explore that. So under any circumstances, while we've known that there's a thing called a shadow docket, it has, by definition, a lack of transparency, which someone might say, well, it's just because it doesn't matter, but we just need to expedite this. But of course, with these cases that are now being brought to the Supreme Court, challenging the authority or trying to extend authority, the concern about that lack of transparency, even for the sake of expediency, is becoming yet another issue. Yes, they talk about the composition of the court and whether we have now a conservative majority and how that weighs in on. We don't need to be political here, but certainly that shadow docket with, I think they said 30 already, have 30 issues have gone through that shadow docket. I can see why people could raise concerns about that or consider it a concern. So in talking about these cases, you're bringing up the importance of the separation of powers. How does the Supreme Court look at that right now? They certainly have much weighing on them.
Yeah. The Supreme Court and Congress have a constitutional duty to make sure that they assert the checks and balances that were given to them in the Constitution, and that they do their jobs, as Bill Belichick might say.
Do your job. But they really are having some challenges. How often does the Supreme Court really get challenged about their own powers?
Well, that's the whole point. If they don't assert their power, they're at danger of losing their power. And there's a famous quote from a president who didn't like a decision of the Supreme Court, and he said, let them bring in their own army to enforce it, so to speak. We don't need to get there. We don't want to get there. That's not where we belong. What's more important than a political position or some kind of leaning towards conservative or liberal or moderate or whatever it might be is making sure you protect the institution that you work for. So if you are justice of the Supreme Court, you need to make sure you're protecting that institution. If you're a member of Congress, you need to make sure that you're protecting that institution, and you need to do your jobs. So, that being said, the problem with the shadow docket is there isn't a well-reasoned, laid-out decision that cites precedent and gives precedent for other cases to follow. And so the Supreme Court historically hears cases and writes opinions that are precedent. And it's important for the Supreme Court to set precedent so lower courts know what the rules are and how to follow them. And so the Supreme Court, as we know, sometimes will say, well, wait, that old precedent is no longer what we're going to follow for whatever reasons. And I actually have some issues with that, unless there's been some kind of real change in the world that requires that. But I'll give you an example of one that I think is going to come up this term. And it's the independence of agencies in the executive branch. When I was in law school, so this precedent goes back thousands of years. I'm only kidding, it wasn't that long ago. I remember studying a case called Humphrey's Executor, and it talked about the power of the president to remove someone from an independent agency. And it said that he didn't have the authority to do that in that particular case for the reasons that were laid out. And what the executive branch has done is remove many folks from independent agencies, and those cases are being challenged. And my concern is the Supreme Court going to reverse the long-standing precedent set by Humphrey's Executor and say that the president has the authority, for example, to remove a governor of the federal
FTC they had for one.
FTC, but more importantly,
the Federal Reserve.
Federal Reserve
was that
yeah,
one.
Right. That sets interest rates and so forth, which has always enjoyed a very, very strong independence for the very reason that we don't want politics to affect our economics and our economic policy at that level. And so it would be, in my opinion, a disaster for the Supreme Court not to follow its own precedent in that particular case.
It's interesting. I know they're not supposed to be making choices with light and transient causes. The causes, I know Mr. Trump says in some cases he has causes. Won't that be interesting as that plays out? But of course, there's some thought now too about with what had happened last time around, where Justice Roberts had sort of emboldened the president by giving him that word absolute immunity from being prosecuted while he was sitting. I mean, that has enabled him, I think, to push each of these boundaries that you're talking about further. So when we think about where that's going right now, there are an awful lot of cases, and you just started to allude to a few. I'm almost tempted to say, gee, David, what Supreme Court cases aren't related to the president and his administration these days? Of course, there are some.
There are.
But what do you think of the most key or consequential ones that you were starting to allude to regarding our president? Right. I think he has some of the top billings, I think.
A lot of the docket is crowded with these kinds of cases. I think
tariffs. Tariffs.
Yes.
We didn't even refer to those, but that's one of the hot buttons, isn't that?
Yeah. So again, that goes back to checks and balances in the Constitution, and in theory, Congress does tax and spend, and tariff is a tax. And the president has tried, or the executive branch has tried to create tariffs under different particular rules or reasons that they have. But what they really have done in effect, for the most part, is done it not really for policy or whatever, but it's almost quite clear on its face. And even the president has said, look at all the money we're bringing in. It's being done as a revenue source. And that is outside of the authority of the president. And my concern, if I was on one side or the other, but I'm here as an attorney just taking a case for whichever client wants to be represented, my concern would be if you are supportive of the president and his positions and what he wants to do. Remember, whatever law you pass today, whatever decision the Supreme Court makes, is applicable to whoever the next president is. And if that's somebody who has a different political bent than you do, or might want to do different things than you would like, you've given that president all the same authority that you're giving to this president, and you're opening up the door to be on the other side of things that you don't like, which is why I think you need to be very careful and thoughtful in what you think the authority and extent of authority of the executive branch should be.
Well, as I recall, when that first came up, the president said, this is an emergency. These are my emergency powers. I don't know if that's legit. I don't know what constitutes emergency powers, but I remember distinctly that he said, I've got a right to do that. And so he's been doing this. Now it's going before the Supreme Court. What happens next?
And so any president should be able to do that. And then that can be challenged in a court. And the court has the right to decide whether it's a legitimate emergency or just an excuse. And that's what's happened at the lower court levels that's been appealed up the chain. And if the Supreme Court allows the president to decide what an emergency is and not the courts, they're taking away power from the court and they're extending the power of the executive branch. And that's something that everybody has to live with, no matter who the president is on either side as you go forward. And it's not our political system that I think you would want to live with, whether you're on one side or the other, because either side can have the issue with a president from the other side, so
and of course, excuse me, doesn't it also challenge Congress's, Congress's purview as well, where ordinarily, even if the president wanted to do this, he'd consult with Congress, they would approve or disapprove, they go back and forth, but he sort of circumvented that. And if you talk about the separation of powers, there's also supposed to be some checks and balances, which are going to be going unchecked if these precedents are set.
Again, Congress has its obligation, just like the Supreme Court does, of exercising its authority. And that comes in a number of different ways with their authority. They need to assert their authority to, for example, set tariffs. If there's a majority in Congress that thinks that, yes, you know what, we need to have these tariffs, and the president should say, I want you to pass a bill that says these are what the tariffs should be, Congress should exercise its authority to do that. They shouldn't defer their authority to the executive branch. And there are a number of other things, oversight and all other types of things that they need to assert their authority on.
So, you know, what we're discussing here, of course, brings not just will they or won't they allow the tariffs to stay, but actually how it impacts the whole of the system. It's a systemic issue as much as it is flipping a coin of the tariffs, no tariff situation. Another one, and I guess this is also a presidential issue, you referred to it a little bit earlier about, I think it was Slaughter. Yeah. She was let go as a Federal Trade Commission, not the Federal Reserve Governor.
Right.
There were two names. One was Cook and one was Slaughter. I get them confused at times. But when it comes to Federal Trade Commission, we don't like her. We were going to get rid of her. Why did that? How does that end up going to the Supreme Court? And it seems like that should have been intercepted.
Again, it's based on the authority of the president to control the executive branch. And there are certain agencies where their independence has been established by acts of Congress.
By Congress, right.
And there are other agencies that were established by the executive branch. And historically, the president has had control over the agencies that have been established by the executive branch because he's in charge of the executive branch. But the agencies that are set up as independent agencies by Congress, the amount of control the president's supposed to have is supposed to be limited, and that's what's at issue there.
So then would it also apply, suppose it gets to stand, that firing remains as it is, does that not also push or open the door to additional firings at other agencies that Congress already designed to be independent,
Yeah.
there's no end to that,
It
correct?
depends what the Supreme Court allows in terms of authority based on the type of agency. So if the Supreme Court says that the president can remove a governor from the Federal Reserve,
that's the other one.
that opens
That's
up the door for
Cook.
just about everything.
So in that case, though, it wasn't just that he was getting back at somebody else who was appointed in the Biden administration or whatever else, but we could fire her for cause, didn't like her policy. Is that a reason that a president should be in that place to be firing someone?
Policy is not a cause. Committing a crime, not the allegation of committing a crime, but being convicted of committing a crime should be the standard.
So does the Supreme Court take criminal cases, though? I mean, suppose
they review criminal cases.
They review criminal. So if he were able to say her monetary policy stance caused something criminal to happen, would that have given him more justification? No, it would not. Okay.
Because it's still policy.
It's still policy.
Yeah.
Interesting. So he's been slashing budgets. It's nice to watch your bottom line, of course. Grants to universities, education. Each one of these, I guess, is a separate issue that the Supreme Court is going to take up. It's about his power, but are they able to lump them all together and be able to say, let's put a kibosh on, or let's constrain his powers and his ability to cut everybody's budget because we don't like the policy, we don't like whatever. Is he able to, are they able to do that?
I don't think you can group it all together because there's different authority over different types of things. So the authority over grants to universities and the reasons for cutting those may be different than a grant to an agency, so to speak, that's being funded by the government, but it's a governmental agency. So different rules may apply to those things.
I guess that makes sense, but considering they're all involved with his power and his ability to cut budgets, and in a similar way, I'm sure what you're saying is true, there are immigration issues about the deportation of the Venezuelans, and then there was another deportation issue about them going to another country, a third world country, and whatever. So those can't be put together either, but they're both impacting on his ability to lord it over immigration.
Generally speaking, each case rises and falls on its own merits, and you don't usually try to make a class action case, you could make a class action case, but you don't generally group them together, 2 or 3 or 4 separate cases, unless there is one thread, one law that needs to be decided that runs through all of them.
And it can't be his power.
Not in and of itself.
Not in and of itself. Do you think that there's going to be an issue about how many cases that he's brought before the Supreme Court versus all of the others that have merit as well?
So theoretically, when they vote on the cases, they look at each case on its own merit. I don't think there's supposed to be a cap necessarily on what they'll hear. So if there's a case that has merit, then shouldn't be saying, oh, we can't hear that one because we have to hear these others.
It's going to be an interesting year for the Supreme Court. We hope that this has been of interest to you. We hope you'll continue to stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.